All right, everybody, thanks for coming. We've got our lovely panel. Everybody made it in, no traffic because it's school vacation week, so hopefully that wasn't too bad. So I'm Portia Katie. I'm a partner in the Nutter Corporate Department, and I'll do the formal introduction, but I have the memory of a goldfish, so I am going to be reading notes. But I will tell you that all of these three esteemed guests are close personal friends, and I want to thank them for all being here and participating. So I'll get going in the formal remarks. So Ellie, we'll start with Ellie, is a member of the corporate team here at Nutter. She specializes in emerging companies, VC work, small business. She provides guidance on all stages of the company life cycle and also does a lot of investor work. So if you need any advice, reach out to Ellie. Julia is a seasoned impact-driven investor. there's a lot with Julia, so here we go. Julia is a partner at Desert Bloom, which invests in food companies with a focus on health and sustainability, who can compete with and create viable alternatives to traditional brands. She is also co-founder of Trophy Holdings, an investment platform that supports companies and funds focused on improving human and planetary health. And finally, she is the co-chair of impact investing at Nexus Global. Nexus Global, if you don't know, is a community of young philanthropists and social entrepreneurs seeking to solve many of the world's current global issues. And our belle of the ball today is Charlie Hernandez. He is the founder and CEO of My Pocket Lawyer, which is the topic of today's discussion. But it is an online platform that uses AI to give help to consumers in the legal industry. It has a mission to democratize access to legal services, which we will obviously be talking about. Charlie grew up in Los Angeles and received degrees from Harvard Law School and Harvard Business School and Harvard undergrad before becoming an accredited attorney. He is a finalist for Innovator of the Year at Florida's Legal Awards and is a frequent speaker on legal tech, access to justice, and venture capital. Prior to his work with My Pocket Lawyer, Charlie founded the fintech company Creo Diverso, which provides financial resources and education to under-resourced immigrant communities. Creo Diverso was named TechCrunch Disrupt Top Pick Company and has attracted investment from firms including Bessemer Venture Partners, Point72, and Torch Capital. Charlie also speaks 4 languages and spends time in LA, NYC, and Miami. No big deal. My Pocket Lawyer uses AI to give online help directly to consumers, as we discussed. I'm going to play a demo, which has recently gone live. It's about 4 minutes, but I think it is the best way to understand how AI is going to be impacting the legal industry. So here we go.
Is there such a thing as equal access to justice?
We are declaring with one voice that our justice system must be based on facts and laws, not access to wealth and resources.
Appearing in housing court is by itself an intimidating experience that can have tragic consequences without a lawyer by your side.
Every year, millions of people represent themselves in court, and the reason is almost always financial.
What we're seeing is a system that is not respecting their constitutional rights.
For far too many Americans, justice is a commodity that they feel they can't afford.
The most profound right that makes every right possible is access to legal representation.
The entire legal profession is about to fundamentally change.
It's a new platform. It's powered by AI to provide legal resources to small businesses and other communities.
My Pocket Lawyer is a free AI tool that translates complicated terms in legal documents to language that we can all understand.
My boss stopped paying my salary. What can I do?
I'm sorry to hear that. I'll do my best to make sure you get what's owed to you. To assist you effectively, I need to gather some additional information. Let's start with your location and your employment contract.
I'm in California and I just uploaded my employment contract.
I've received it, thank you. Please share any other communications with your employer. Here are some types of communications you might want to look for.
Can I upload a screenshot of a text message?
Yes, my Pocket Lawyer is multimodal, meaning you can share photos, documents, audio, or text. You can even forward email threads directly to me.
What if some of the texts are in another language?
I can give my answers in any media or in any language, which helps users who are visually impaired or face literacy or language barriers.
Okay, great. I've uploaded everything I have.
Here's a list of the materials you've shared with me that I'll use to evaluate your case.
Is my information secure with you?
Yes. Everything you share with me is private. We use full encryption and security measures, only store these documents as long as you'd like us to, and won't share them with anyone without your permission.
All right, so do you think I have a case?
Yes, here's what we can do for you. Given that you are located in California, we can outline potential causes of action and next steps, including breach of contract, wage theft, unfair business practices, and labor code violations.
So what are my next steps?
Let's start by calculating the total amount owed to you. Based on our analysis of your employment agreement, you are currently owed $150,000. Then we can send a formal demand letter to your employer requesting the unpaid wages.
All right, I want to send a demand letter.
Here is an outline for a demand letter in your situation.
Okay, I sent them the letter and they sent me back this agreement. Can you explain it to me?
Sure. This is a settlement agreement, which asks you to consent to a set of conditions in order to receive your salary. Below is a summary of the key provisions of the agreement and an explanation of how they would affect you.
Okay, I think I want a lawyer. Can you help me find one?
Certainly. Here are some options for employment lawyers near you who specialize in unpaid wages.
How much will a lawyer cost?
The cost of hiring a lawyer can vary widely. Here's how much you could expect to pay in a few different scenarios.
Are there any cheaper options?
For cheaper options, you might consider legal aid organizations, law school clinics, or pro bono services. Here are some legal aid organizations near you. Heads up, there are restrictions on who they can accept as clients, but I can help you determine if you're eligible.
Okay, let's go with the first lawyer on your list.
I agree. With your permission, I will package all your case information to send them. This will save you time and money when you meet with your counsel. Once the law firm has your case information, it will be protected under attorney-client privilege, even during the initial consultation.
Is there anything else I should know before my meeting?
Yes, here is a list of questions to bring with you. This will help you get the answers you need faster and help your attorney be more efficient in handling your case.
Okay, so I'm going to turn it over to Charlie to give us a background as to why he founded the company and the background behind what we just saw.
Thank you. Well, lovely being here with you all. Thank you. I've always been very interested in creating something good. After wrapping up grad school, a sensibility for that. And I thought that there was an opportunity at that point to do something similar to what we did here, or we're doing here in my pocket lawyer in the space of fintech. So I started a fintech company called Crediverso. And as Portia described it, we're a financial education and resource platform for recent immigrants. So a lot of non-English speakers, a lot of people who just arrived here. And among other things, we built out the first credit check in Spanish in the country, which didn't exist until a couple of years ago, if you can believe that. We built out banking products for undocumented people, a lot of stuff like that. Company's still around. And I'm really proud of the work that we've done there. But what was interesting is that over the course of all the conversations we had with the consumers of Creativerse. So we realized that all these people we were helping get access to financial resources for the first time because they never had access to them before. They also didn't have access to legal services. And now that's not very surprising. Someone who doesn't have access to the financial ecosystem wouldn't have access to the formal legal ecosystem. But that was our initial observation, that there was this pain point that existed there. Now, the second one was that this was right around the time where generative AI started becoming commercially adopted and really having a lot of utility and potential benefit within the legal space. There was a third observation that there had been a lot of investment, a lot of VC investment into enterprise legal technology. So this is tools and software for lawyers inside law. These are companies that you're all very familiar with: Harvey, Spellbook, Co-Counsel, and in the past couple years, there have been hundreds of millions of dollars invested into these companies. So to take a step back, this got a big problem, big pain point with consumers not having access to legal services. And this goes very deep. And, I think it's as big of an issue as it is for the average person out there. Once you get into underserved communities, low-income communities, it's something like 92% of all civil legal issues go unaddressed, because as we all know in this room, under the Sixth Amendment, we're guaranteed a right to counsel, but if you have for a criminal issue, but if you have a civil legal issue, you're not guaranteed anything. So many people end up having to go advocate for themselves in court and really important matters such as family law, housing law, bankruptcy, and they face adverse outcomes. So that was first observation. And then again, you've got a really interesting technology that has some high utility here and investment that is only going to one sector, but is not going to the far broader set of use cases. So we looked at all of that and thought, what can we do that's interesting here? We had some engineers already on the team at Crediverso who had a deep AI and machine learning background. And we thought, let's see if we can find a way to give legal information directly to consumers and small businesses. And so that resulted ultimately in the video that we just saw by Pocket Lawyer. So maybe I'll stop there on the backgrounds and pass it back to Portia.
Yeah, so I think if anybody was here for last week's discussion on AI, one of the key points that was evident is a lot of people just don't understand what AI is and how AI evolves and how it learns. So can you give us a high level explanation of the technology used in My Pocket Lawyer and how the AI is trained?
Yeah, it's a great question. So we use about 50 different pieces of technology that we stitch all together. Some of those are large language models. We use machine learning techniques. We use natural language processing. And I'll just give a quick overview of what all that means within the context of My Pocket Lawyer. So large language model is a type of artificial intelligence that basically is very good at processing and generating natural language. That because everything that we do in this building, everything that we as lawyers do has to do with language. That is a very high utility technology for the set of tasks that lawyers have to do. Now, natural language processing, the way that we use that here is that you saw the interaction, the dialogue that the consumer in this use case had with the technology, and the way we've tried to recreate it is basically to recreate a virtual law firm. And so that is everything from when somebody first walks in the door and has that initial interaction with, and by the way, just to take a step back, I'm talking mostly about small and medium-sized law firms here. I'm not talking about big law. We're not talking about M&A, private equity work, bankruptcy, stuff like that. We're talking about the type of work that happens for solo practitioners and for small and medium-sized law firms. So client walks in that door and a receptionist or an intake office has to go through all of that back and forth on understanding what is the nature of the problem, what are all the documents that you have to upload or to share that have to do with this case. And so we have a specific set of technologies that are very natural language processing focused to understand where's the person located, so what type of case law will be relevant here. Then we pass it off to what we call the librarian technology. Librarian technology is functioning very similar to how a librarian would in this office. And their job is to solicit any documents that are relevant, that are going to be important sources of data for the results that we produce, and then also connect to the right databases. This is really critical. So we connect directly to state and federal judiciary and legislative databases so that we can get comprehensive, accurate, and very importantly, up-to-date information so that when the law changes, we know about it. That's the natural language processing element. There's a third technology called retrieval augmented generation, which is RAG is how people refer to it a lot. And I think now might be a good time to talk about, we get a question very often, why can't ChatGPT just do this? And it's an interesting question. the first way I typically answer it is, um, we've all seen those articles about the hallucinated case briefs, right? And for any of us who haven't, basically there have been a variety of lawyers who have decided to use ChatGPT as they would LexisNexis or Westlaw and produce case citations directly from ChatGPT. Now, the challenge with that is that ChatGPT, it's a large language model, and it is what's called pre-trained on the entire corpus of data that's found on the internet, which is not, I like to think about it as it's very street smart, but it's not book smart. It knows where to find the library, but doesn't know exactly what book to pull. It doesn't have all that information memorized. And so if you try to use that for specific case information, it's really not actually that good at that. So it can lead to these hallucinations. Now, there's a second reason that's, I think, really critical when it comes to understanding how this technology can benefit or not benefit consumers who need access to civil legal help. And now, remember a moment ago, I said that most of these large language models are trained on the entire corpus of data on the internet. Well, typical person on the street, the last case they read about on the internet is probably a Supreme Court case, right? It is almost certainly not a state civil court case. However, that is where most justice happens. That is the most relevant set of information for somebody who is advocating for themselves, who's going through a civil legal issue. But because it's not interesting, it's not relevant for mass media, it doesn't get covered on the internet, it doesn't get included in the body of data that a ChatGPT would pull from. So that's where we come in. We connect directly to those databases so that we can actually provide information that is relevant to it. And we use this technology I mentioned a moment ago, retrieval augmented generation, which combines the best parts of generative AI, meaning it's generating the right text, with retrieval. So it's going into that specific piece of data to find the answer that's needed, and then it generates from there. So I hope that was maybe not too high level and not too in depth, but that's essentially how we use this technology.
Yeah, one of the issues that came up, a journalist was a guest at last week's event, and his concern, to your earlier point, was how do you verify sources? And does My Pocket Lawyer have the ability to ensure that sources are not just accurate, but verifiable? And the key point that he made was, in this age of misinformation or opinion pieces, how does the technology ensure that the inputs are verifiable, and if the technology is there or not?
Yeah, no, it absolutely is. And I think the key here is multiple redundancies and where you're pulling the data from. So if you take a look at, we describe now this piece of technology that exists inside the virtual law firm we've created as the generalist partner. And the role of that piece of technology is to decide which data to pull from to produce the set of answers. Now, that data can be the documents that are uploaded, they're being held by the librarian. It can be state court information, case law. It can be federal legislation, statutes. It can be secondary sources authored by law professors or academics. And many of those pieces, it could be government websites also. And so the key there is that it chooses from amongst those based on what the appropriate, is doing that kind of reasoning, what the appropriate answer should come from. Now, on the multiple redundancies portion, there's one piece of technology that actually goes out and solicits that. There's another piece of technology that goes and double checks it. There are then many other pieces of technology that go and argue amongst themselves to say, hey, is that accurate? Does that produce the right answer? So that's everything that's happening behind the scenes. Now, by the time it actually gets to a user-facing portion, it's all linked, it's all cited, it's all right there. So all you need to do is click. And it's one thing that ChatGPT can do is produce a hallucinated case brief, but it's not going to produce a website link. Actually, it might produce a link, but it's not going to produce a website, right? You can't go click that website and get to a real website that it just made up for you. So what we'll do is actually have that website, the direct source right there, so you can double check it, even if you don't trust the multiple layers of technology that we've gone and checked it for you already. Right, one of the pieces of technology just goes and makes sure that, yeah, that's an actual website.
Yep. And we spent a lot of time last week talking about that exact point. So that's helpful for anybody who wanted to know a little bit more about this product. So I'm going to turn it over to Julia. So Julia, as an investor, obviously this is a new disruptive technology. It's hard to place a valuation on it. It's hard to verify the IP. Can you give a little bit of perspective as an investor as to how you would view something like this, whether it's from the impact, access to justice space, or just as an investor generally.
Yeah, absolutely. And thank you for having me here as well. We are, I think, really on the precipice of this, highly disruptive technology that's going to impact our lives in many, many ways. From the investment side, and again, through the lens of impact, there is clearly a very compelling story here about democratizing access and making sure that people who otherwise might not have the means, the resources to be able to have this type of information given to them. And as the video showed, actually package an entire case file. They can go out and get the right type of legal representation and help. I think as you consider valuing a company and thinking about, the total addressable market size, I mean, there's no doubt this opportunity is massive. There's also, and again, this comes more from the potential negative externalities standpoint. We're always thinking about what could the potential negative externalities look like with anything, whether that be a product, whether that be a new technology that's on the scene. And I think with this, I'd be curious to know from your standpoint, there's a lot of dialogue right now around how do we prevent potential biases with AI? And when you're talking about potentially underrepresented communities and the data that it's pulling and then also sort of sharing with various different customers and clients, how do you potentially prevent any type of biases that we do end up seeing with a ChatGPT based on the sources that you talked about versus a very sort of finite and specific curated source that you're pulling from right now? Do you find that there are potential negative externalities around that? Because that is, of course, a factor into how we think about valuing a company, thinking about the long-term sustainability of a company. So maybe just a little bit more context on that could be helpful.
It's a really important question, and maybe I'll take this opportunity to frame it within the larger question that I'm sure will come up today, which is the reason why I think the legal profession at large has historically had some level of opposition to technology performing this set of roles, whether it's technology or paraprofessionals actually, has largely been around this idea that it has the potential to cause consumer harm. And I think that's part of what you're describing, that if there are embedded biases into the data sets that these models are trained on, what happens if it produces a result that causes some consumer harm? And I think the way that there are a few ways to think about that, but there's one really important one, which is let's take a step back, and you always want to evaluate that within the context of what is the existing framework, what is the alternative. And so we're considering technology that might cause some future potential harm. And that's very important to consider. But let's also remember that there is real consumer harm happening right now at a far greater scale than anything we're talking about here. So we saw the stats in the video, there are millions of people who are having to go through family law issues. This is child custody, divorce, employment law, wage theft, housing law, landlord-tenant. I mean, landlord-tenant issues, in 98% of those cases, the tenant is unrepresented. Almost 100% of those cases, the landlord is represented. So you can imagine what the outcomes look like there. So that is the background that we are operating within now. So some might say it's, any improvement upon that is an improvement. Now that's not good enough for me though, and I think that should be good enough for you or for the folks in this room. So how do we ensure that even beyond that, we can counter bias that's included in training data? We can make sure there are security measures embedded here so that client information is safe and protected. And those are all things that we spend a lot of time thinking about. So, on the bias side, this is where it's important to have the right data. I think everybody in this room spends a lot of time thinking about how to access that right data. But again, you look at what the alternative is now, and tens of thousands of people every day are accessing ChatGPT to get legal help. They're asking legal questions to ChatGPT. And we've spoken to the team there, and that's happening. And remember what we described a moment ago about how that is not trained on the data that is really most critical for somebody who is trying to engage with the justice system from a consumer standpoint, from a security standpoint. So that's something I'm sure we'll get into today also. And I think that also falls under the broad umbrella of what where potentially consumer harm can come from. So we don't store the documents, right? We only store them as long as the user needs. The questions that users ask are only stored for a finite period of time, and they're done so on an anonymized basis, basically for us to better understand how people are engaging with the tool, whether they're asking questions that are of a corporate law standpoint, venture capital law, housing law, criminal law. We want to understand that so we can better design the product. But again, the alternative, ChatGPT 3.5, which is the version that's publicly available that somebody who probably can't afford a lawyer has access to, they explicitly say in their terms and conditions that your information will be used to train our model. You can opt out of that if you can afford the paid version. We don't use their information to train our model. And as I said, we don't store the documents and we only store the questions in an anonymized format. So it's really important to keep in mind these considerations of consumer harm and bias, security, and we're taking great efforts to ensure that those are at the forefront of our engineering and legal ethics efforts. But again, it's against the backdrop of what is happening right now, and I think it's almost indisputable that it's an improvement over the existing landscape.
Yeah, and thinking about sort of product differentiation and also making sure I address Portia's question around how you would think about valuing a company like this in a space that, again, we're really just seeing these new technologies come to market. I think, the obvious train of thought is thinking through exit opportunities and potential. And when you think about applications today, and again, sort of within the context of what you shared, but also, we've seen a bit of, and maybe we'll see a bit of a teaser for how it can be applied within venture capital. And you think about, larger organizations like a PitchBook wanting to get involved and how relevant this can be, not just to underrepresented communities and from an equal access standpoint, but as those larger players get interested in this type of technology, what type of path you want to continue taking this technology down, if it's within kind of the same umbrella of what you're doing today versus, many different applications as the technology continues to evolve and grow. And so, there is a lot of sort of the evolution, the natural evolution of where the technology can take us.
Yeah, I'll just say one quick thing on that, and because I want to make sure we get Ellie looped into the conversation here. So legal tech today, I think, is where fintech was 15 years ago, back when it wasn't even called fintech, back when it was called payments. And I think that's because the regulatory space is starting to shift. People are just starting to understand how the technology could be applicable to these different use cases. And I mentioned at the beginning of our conversation that there have been millions of dollars invested in these enterprise tools, right? You just mentioned one of them. But there's been nothing invested on the consumer side. And this is actually an interesting parallel to what happened early on in fintech. Some of the first fintech platforms were built to service investment bankers inside investment banks. But at the same time, you have this massive market of consumer retail banking. And so for us to focus only on enterprise legal tech and to ignore all of the consumer opportunities would be akin to only building tools for investment bankers inside investment banks, completely ignoring consumer retail banking. I think that's a parallel that, because there are so many venture investors out there with background in fintech, they can relate to and understand within that context very easily.
So to Charlie's point, I want to get Ellie's perspective, if you can, Ellie. Say you're wearing an investor hat as investor counsel. Can you give a little taste as to how you would advise them when looking at a company in the AI space? And then relatedly, if you're company counsel, what are some of the things that we need to call out looking at investment in this space?
Yeah, it's a great question. It's something that we're always thinking about it from both sides, right? Whether you're on the company side or the investor side, goal for company is to build out your business, to be able to have it be the best that it can possibly be for the consumer, for the potential exit. And in order to do so, you need money, right? You need to bring in money. The valuation question that Julia mentioned is really interesting. How do you value a company that's so new in this space, that's the technology's new and it's always changing? It's hard to do so. And you can really only raise on promise once, right? You can go out to the market and say, hey, we've got this great idea. We've got this thing. We think it's doing these awesome things. And we need money in order to build up the team. We need money in order to focus on research and development. And here's what we're going to do. You can do that once, and then you have to prove that you can do it. Here, there's all sorts of different angles, I think, from the company side that you could kind of either tug on the investor's heartstrings, talk about the access to justice, be able to say, look, this is a technology that's going to help underserved communities when they go to housing court. They can ask these questions. They don't have access to lawyers and they can't pay big legal fees, but we can give them just a couple of nuggets of information to be able to help them and really kind of engage the community in that way. An investor that is interested in sort of impact investing is going to really benefit from that. You could also go on the flip side and say to some of these bigger folks in the PE space or the larger VCs to say, look, this is something that's coming. It's something we can't avoid, and it's something that's disruptive. We're going to make a lot of money off of it, right? And so I think folks are going to jump at that opportunity as well. And so it's an interesting dynamic between those two different and competing outcomes to be able to say, like, what's your goal, what's your vision, and how are you going to convince an investor to join you there? From a kind of company perspective, the other thing we always look at is what are the potential pitfalls? What is an investor going to care about to make sure that their investment is safe and that they're going to be able to see a return on their investment? With any technology company, IP is key, right? And I think here, some of the questions that I have for myself is, who owns the IP? Who owns the software? Who owns the algorithm? You hope it's the company. But when you're getting data and questions from consumers, does that get integrated into it? And how do you make sure that that data is protected from a both kind of privacy standpoint, but also from a standpoint where it's fully ingrained and integrated into the company itself? And so making sure that you're kind of crystal clear as to that piece of it so that you can say to investors like, yep, there's no problem. No one's going to come after us for the IP. No third party is going to claim that, that this is theirs and not ours. Because anything you can do to convince an investor that everything is safe and everything is within the confines of the company, I think is a good thing.
Yeah, I want to give Charlie, do you want to react to that? Or we also have the second demo. So I'll
I
give.
think that might actually be a good segue.
Yeah.
Because, you're right, you highlighted almost two different angles. Which is one, you've got this really interesting consumer use case, and you have this massive market of people who are clearly underserved. And I think, by the way, beyond well, I'll just mention actually one stat that I think is very interesting. So the extent of demand for legal services in this country outpaces the capacity of lawyers to meet that demand by 55 times. So said another way, that means there will never be enough lawyers to service all of the demand that exists out there for legal issues. By the way, that doesn't yet include all of the latent demand that I think as we start to make legal services more accessible, people will realize that they have more legal issues than they previously thought they did. And then it also doesn't include all of the issues that people don't even realize yet that are legal in nature. So there is a massive market on the consumer side there. And that's why I love the comparison to consumer retail banking, right? How many multi-billion-dollar banks are out there? But what's interesting is that you also have this opportunity to say, hey, this is a scalable, profitable venture, and there are multiple ways to monetize, multiple ways to make money, and those don't necessarily have to be at odds with helping out those consumers. And so I think one thing I observed early on as we were having conversations within the venture community is that the video that we all just saw, that highlights a consumer use case of wage theft, right? But and perhaps it's no big surprise, most venture investors have never had to deal with a wage theft issue, at least not personally. And so while that's an interesting use case, and as you said, maybe it's an opportunity to tug on the heartstrings of investors, maybe it limits you in terms of your investor pool to just impact investors. So what we did is we said, all right, well, we've built basically this generalist virtual law firm. Can the same technology and the same data be used to service a venture use case? And so we went and we looked and we saw people were already engaging with it that way and already asking questions about equity financing agreements and so forth. And so we said, all right, let's make a demo that is a little bit more accessible and relatable for a typical venture investor. And that's what we have here.
For the lawyers in the room, get ready.
Can you summarize each section of this equity financing agreement for me?
Sure, but before I begin, please make sure to upload any additional schedules, exhibits, and side letters.
By the way, this deal is confidential. Is this all secure with you?
Yes. Everything you share with me is private. We use full encryption and security measures.
Okay, I've uploaded the side letters from the other investors.
Great, here's a summary.
Are these terms market?
Here's what I found after comparing the terms to market benchmarks and our contract database.
Can you explain the lick-pref clause to me?
The Series A1 preferred has a 1x non-participating preference, but the Series A2 preferred introduces a 2x participating preference with a cap at 3x the investment.
Here's a copy of my firm's standard agreement template. Does this diverge from any of our terms? I'm worried about the drag-along rights.
There are several divergences, including in the drag-along rights provisions.
Can you draft a new drag-along rights section that is a midpoint between this agreement and our template?
Sure.
Thanks. Here's the cap table. Can you validate the math?
The math behind the financing structure, including dilution effects, liquidation preferences, and convertible instrument conversions, all checks out.
How can we ensure we don't get diluted too much?
Section 6B references milestone-based tranches that could trigger further dilution. In light of this, it's essential to secure a robust anti-dilution clause.
Okay, anything to worry about on structure and governance?
Can you share any charter documents or bylaws?
All right, uploaded.
Overall, the company's structure and governance are solid, but there are opportunities to better protect investor interests.
Are they violating any regs?
Data protection, employment law compliance, and financial regulations are areas that require attention.
Are there any conflicts of interest?
According to an internet search, a key executive has a close relative in a regulatory body that oversees fintech operations.
Anything else I should be thinking about?
Considering the complexities identified, escalating these issues to outside counsel is recommended.
Please structure this into a Word document and email it to me.
Done.
Thanks, my pocket lawyer. This lets me spend my time negotiating the important points, not reading through boilerplate terms trying to find them.
Okay, so I'm going to turn it over to Ellie first, because I think that that's probably the most relevant.
Yeah, this was an interesting one. When I watched this case use, it really struck a chord with me because this is what I do every single day. Every single day. You know, I'm constantly on the phone with clients, looking at financing documents, walking them through these boilerplate terms because on the company side, a lot of times this is their first venture into any sort of institutional investment that's coming in. And so we're going to get these form documents and we want to make sure they're protected and we want to make sure they understand what their rights are and what the dilution might be for them. And so, you know, as a lawyer of emerging companies, I've got that hat on where I'm like, okay, these are the things you should be thinking about. And then as a lawyer of emerging companies, I see technology like this and I'm like, how am I going to make sure I'm not out of a job in 5 years? And I'm sure you get that question a lot. And I really started to think about, okay, you know, if this is technology that's coming, what are the ways that I as a lawyer can set myself apart from the tech? And I loved that at the end, my pocket lawyer said, you know, I think you should engage with counsel, because that's what we always say to our team as well. But it's true that if you're a startup or you're a new company and you have the funds that you have and you want to make sure that you're investing it in your people and in the R&D, you're not necessarily going to want to take that and spend thousands of dollars on legal bills if you don't have to. And so, you know, as a founder and as a former lawyer, sort of what are the things that you're thinking about in terms of, you know, is this intended to replace law firms? Is it intended to supplement law firms? And sort of where do you see the technology going?
It's a great question. We do get this question a lot. And I am aware that the only way we can create widespread adoption of this technology, especially when there are regulatory considerations to keep in mind, is by doing it in a way that encourages widespread support from both the financial community, the legal profession, and consumers at large. So there's one quote I really like here, which I heard from a CEO telling his outside counsel recently. He said, "You have no idea how much work I don't send you every year because of how much it costs." So I think this touches on an important idea of latent demand. And if a typical small business has 3 legal issues a year, 3 civil legal issues a year, that's, that's a number, but that is a number that is based on where it tracks to where the threshold of addressing that legal solution is. And so if the threshold to address that legal solution is I have to identify a lawyer, find a lawyer, I have to vet that lawyer, and then I have to pay that lawyer, yeah, you're only gonna have so many legal issues every year. But if the threshold is just pull out your phone and ask a question, all of a sudden you find you have a lot more legal issues because you can get such a fast legal answer to those. And what that means for lawyers is that only the most complex, only the most important cases get elevated to lawyers. I think conversely, and this is actually something I talk about a lot on the consumer side, is not creating an easy pathway for people to access legal services is both a civil rights issue and an economic issue. On the civil rights side, we effectively have this whole portion of the population that doesn't have access to civil rights because they can't afford a lawyer to help them access those rights. On the economic side, it is often the most entrepreneurial people in our workforce who are prevented from starting and growing companies because they don't have access to the legal tools they need to do so. So by creating a smoother pathway for people to answer via technology those simple legal questions and then only escalate the most important complex legal questions to attorneys, it actually expands the economic pie rather than shrinking it. So my expectation here, especially against the backdrop of how the massive mismatch in supply and demand between legal services demand and supply of lawyers, is that we will only create far more work for lawyers rather than reduce the work for lawyers, and probably in the process create more lawyers, period.
So I think I want to turn it over to the audience to see if there are any questions for anybody on the panel. Oh, there we go. Why don't we start with Kate?
Great, thanks guys for being here. We really appreciate it. I'm a lawyer in the corporate department as well. And so in sort of hearing your conversation, I had a couple of questions that popped up. The first being sort of, you mentioned your regulatory landscape. Obviously, fintech, as you said, is sort of, you see it as sort of an example for where sort of legal tech is going and with the assistance of AI. And I know that fintech has sort of faced an interesting regulatory sort of environment in the sense that I think, the federal government is notoriously slow to adopt sort of new ideas and new regs. And it's sort of been an interesting it's been evolving over, decades and now. And I'm wondering sort of what are the regulatory hurdles that you're seeing? Like, what are you grappling with? Are there sort of big issues that you see are in your interpretation of sort of your involvement with them? Have regulatory bodies sort of been open-minded about the tech? And sort of, are there issues there that you're thinking about and sort of talking through that you think either you're facing in particular or that the industry itself is sort of grappling with and will be in the years to come?
It's a great question. Certainly something we spend a lot of time thinking about. So for the folks that aren't attorneys in the room, there are essentially 3 sets of regulations here that are probably the most important to consider whenever you're active on the legal tech side in terms of directly serving consumers and small businesses. And so those 3 are unauthorized practice of law concerns, UPL, fee sharing, and corporate ownership of a law firm. So let me address each one of those one by one. So unauthorized practice of law, the idea there is that, not to be too cheeky here, but lawyers like being the only ones who get paid to give legal advice. And so anyone else that enters that space that potentially could give legal advice, there are a series of laws that are designed to prevent that. And in their best light, those laws are designed to prevent consumer harm, right? You don't want somebody out there who's unqualified, holding themselves out as a lawyer and causing some consumer harm. But often, and there's wonderful data to back this up, it just does create a system where you have almost a regulatory intervention in the function of free markets that leaves a lot of consumers out in the cold and doesn't let them have access to the legal help that they need. So, we can kind of go into more depth on why those regulations were designed the way they were and what they actually accomplish. But I think the way that we think about them from a company in terms of protecting ourselves is that we make it very clear via a series of disclosures and disclaimers, and then, providing the right information to users. It's the following things. First, we're not a law firm. We don't engage in the practice of law. We provide only legal information, not legal advice. Those are 2 terms of art that are very important to distinguish. And there is no attorney-client relationship being generated here, and there is no attorney-client privilege on the information.
That was my next question.
And so, you can actually get a long way, but by just having those affirmative disclosures and disclaimers. And so the idea between legal advice and legal information is that somebody who has gone to law school and taken the bar is allowed to give legal advice, but somebody who has not is only allowed to give legal information. Challenge is every jurisdiction has their own definition of what is legal advice versus what is legal information. Even within those definitions, they're very ambiguous. It's very hard to navigate. So, for a company like ours that is very mission oriented and is trying to democratize access to legal help, the way that we approach it is we simply want to get information into the hands of consumers as easily as possible. Now, there are a couple other regulations that are important to consider. One is fee sharing. One is corporate ownership of law firms. And the idea behind fee sharing, and for the non-lawyers in the room, is that you don't want a structure where a lawyer can solicit a fee from a client and then share that with a non-lawyer, because that's effectively the same thing as unauthorized practice of law, right? Corporate ownership of law firm, similar idea. There's a lot of overlap between these three. And the idea there is that for a company to own a law firm, you would create an inherent conflict of interest between the fiduciary duties that the corporation owes to its shareholders and the affirmative duties that a lawyer owes to its client, right? And so you can imagine a scenario where the lawyer maybe would be incentivized to upsell a product to the client that the client did in the interest of the C Corp and generating returns for the shareholders that the client didn't actually. So nice idea in theory, but in practice, I don't think those conflicts are altogether avoided by the law firm structure in and of itself. I mean, it's not as if law firm partners are completely immune to financial incentives. And so it's, that's not something that we spend too much time worrying about because, again, there are different ways to navigate that. We're not engaging in the practice of law, but I think it's another discussion that we could probably go deeper on.
Thank you.
John.
This is great, so compelling, and everyone's so articulate, explaining the points. Super interesting. The culmination of both of the demos was an introduction to an attorney or a recommendation to a series of attorneys. So I'm curious how the technology makes those recommendations. Where are those law firms getting pulled from? And if so, is that an avenue for monetization? And how do you square that with what's best for the consumer? And then secondly, and related, just generally the business model today or in the future. Be curious to understand.
My eyes aren't good enough to see the company you're with there, but I'm going to guess it's someone on the finance side. Yeah, so that's very key for a number of reasons. I think first is that this product, this technology is not designed to replace lawyers, right? It's designed to address those simple questions that people otherwise would have to either Google or go to ChatGPT and get subpar answers for the complex questions, to surface those and elevate those and present them in the right way, in the most efficient way for both the consumer and the law firm to an attorney. So that is a backdrop. Now, what does that mean on the business model and the monetization side? And that's a really interesting question. So we think about monetization in several ways. Remember that the majority of the work that we are doing as a company is going to be for these small, it's going to be the types of legal issues that otherwise a solo proprietorship or a solo practitioner rather, or a small and medium-sized law firm would be dealing with. So we're obviously not going to be able to address every question all the way through. We have no offline capabilities right now, right? It's a small team. I'm the only lawyer on the team. So we're not going to be litigating for you. We're not going to be filing documents yet. So in those cases where we do have to escalate to an attorney, the idea is that we will continue to curate a vetted network of law firms that have both expertise in the practice areas that are identified through that initial dialogue, so that we're, again, offloading that job from the user himself or herself who doesn't maybe have that expertise to evaluate whether a law firm has, well, first, whether their issue is both employment law and contract law and whatever else, and then also how to find a law firm that has those capabilities. So we take that on. And again, we have a variety of technologies that do that, and they can access the internet and, real-time evaluate reviews, things like that. But I think we can be a lot more proactive, and we intend to be, about how we put together that attorney network, and that's something that we are working on right now, and we get inbounds all the time from attorneys who want leads. To that point, the monetization model that I really like is being compensated by the law firms who are trying to generate new business when we hand them off leads. Now, obviously, that's all done with the consent of the consumer, but and the awareness of the consumer. But the nice thing about that is that from the access to justice angle, which is a key part of our mission, it offloads that cost from the consumer to the lawyer. There are other ways to do it also. There's a subscription model strategy that we are testing out. That one, the idea there is that the average cost for an hour of a lawyer's time in the country is about $350 every hour. So for a fraction of that, we can, just with the technology, get you much of the way there through a subscription model. There's a third way that's pretty interesting that is an approach to navigating some of those fee sharing restrictions that you were mentioning. And that's something that's called a two-company model, where you essentially open up a law firm alongside the C Corp. And the law firm doesn't need to be staffed with a ton of attorneys. Basically, the attorneys are leveraging the technology to service those clients, but it puts them in a position to, from a regulatory standpoint, be able to avoid challenges around those fee sharing regulations while still generating revenue besides the company.
Yeah, so interesting. Thank you.
Thanks for the question.
Matt, first of all, thanks for coming to this. I just want to dig into that last question a little bit more, because I understand the model, the business model on the consumer side quite a bit, especially if you build in some sort of referral fee or ultimately have, law firms, maybe paid to advertise or paid to get to the top of your algorithms, however that works. Because that achieves your goal of access to legal services to people that may not otherwise have it. On the consumer side, and this may be getting a bit about the subscription model that you just mentioned, why did you choose to focus on servicing the client as opposed to developing a product that really services law firms through either licensing or a subscription model? Because I'm not trying to freak anybody out, but the two biggest expenses a law firm has are, basically compensation and lease expenses. And so obviously, if there's a way to decrease headcount, you're saving on both of those costs. As Ellie freaked out about, it's what she does. And I love Ellie, and she's going to be here a long time. But if you had developed a product that's more catered towards law firms and had them buy in either a subscription or a license to sort of do a lot of this synthesizing of data, information applied to a set of facts, and then having certain levels of attorney review it as a product going forward from there. That seems to be sort of a different path than client-focused and a different way to monetize what you do. So I guess the question is, why did you sort of choose to go down this path, or was it just sort of an evolution from the more consumer-based model that we saw at the beginning?
Well, for starters, I think it's a far bigger market. You hear these pitches from enterprise legal tech companies describe the total addressable market of law firms. And as the folks who work at Nutter in the room will know, there are budgets that have to be considered. There are a lot of decision makers that have to be included. Maybe the people who are directly benefiting from the use case are not the ones who are making the buying decisions. So it actually is very hard to sell to law firms, and it's a very crowded space. So I think on the consumer side, it is a far easier market to sell to, and it's a far larger total addressable market. Now, that said, I think we actually we have created a tool that services law firms, and I'll tell you how. So you saw in the first video, at the end, two documents that were output at the end of the conversation. One was designed for the consumer, one was designed for the law firm. So I'll take the one that's designed for the law firm first. So that one is designed to essentially replicate the intake process that occurs in a small or medium-sized law firm or at a sole practitioner's office. And all of that back and forth that will be done, that can take several hours and does require a lot of headcount, a lot of resources to do, is engaging with the client over the phone, getting a hold of them, understanding where they're located, what the nature of their problem is, what the timeline of events was, if they have documents to upload. So we saw in here, there was the employment contract, the communications with the lawyer, the text messages, the email threads. It takes a lot of time and energy and manpower to gather. And not only that, to compile in a relevant way and to route to the appropriate practice area within the law firm. So I think in a way, we really are servicing law firms, and that is what they think they're willing to pay for in terms of the money that they would send us for leads. Just before I wrap up this question, there's the second document, right, which is, I think, also in a maybe indirect way, is a service to the law firms as well. So that document, and we just buzzed through it quickly there, but basically what that does is it is a companion document for the consumer when they show up to that first meeting with the law firm. And it has all of the, first of all the information for the meeting, which for certain clients can be really important, how to get there, what time it is, phone number, et cetera. But then all the questions that you need to ask, anything that we haven't answered yet, anything that maybe we gave an incomplete answer to that we would recommend they get a more fleshed out answer from a human lawyer. And what that does for the consumer is very clear. It positions them in a more informed way to be more efficient with that paid hour of time. But for the law firm, you get, rather than a cold lead that you don't know anything about and who has no idea how to characterize their problem to you, you actually get a pretty informed consumer who can ask the right questions right out the gate. So maybe that initial meeting doesn't need to take 2 hours, it can take 30 minutes. And I think that's how we help law firms be more efficient with their time and ultimately see more clients and hopefully reduce the price point at which they're able to address those clients.
I gave you the benefit of telling you where I worked, so you know I'm not a lawyer. But I was curious if you think a future state of the product would be that you do sort of have a closed loop system where you would actually know the outcome of, you know, some of these use cases. Just because I imagine there is value in understanding if your model was correct. Obviously, there is some finesse in law. I'm sure maybe other people would say it is black and white, but I imagine there's law firms that are bringing down that $350 average from where Nutter is. So I'm curious your thoughts if that's something that you're thinking about for the future.
It's interesting. It's a very interesting question. So understanding, being able to utilize all this technology that we're using to understand from the first question that gets asked, the nature of the case and the potential likely outcome, that's extremely valuable information. It is a long ways down the road for us, but you can think, you know, now taking it back to the fintech side of things, you can think what kind of implications that has for litigation finance, for example. It's really interesting stuff. So I think we're a long ways away from that. There is a lot of work to be done here. And what's been interesting is that for I think a variety of reasons, there aren't that many companies that are active in the consumer legal tech space. There are, I would say there's the first generation of companies, that's the LegalZoom, for example. Then there is a second gen, and they were, I think, creating document templates and helping businesses register as an LLC, file trademark, stuff like that. And by the way, there were all sorts of challenges around UPL that they had to navigate for that, as obvious in hindsight. There is a second generation of legal tech companies that didn't have the benefit of all the technology that this has been built on because they were started maybe 5-ish years ago. Fantastic companies though, and they have very narrow fields of legal issues that they address. Now we have this third generation and it's really new. I don't know of any companies that are doing what we're doing right now, but there should be, I think, about 100 more because it is such a wide open space and there's so much work to be done, right? As you start thinking about how you can be active, like in evaluating the outcomes of personal injury cases and medical malpractice and all sorts of stuff. So we have our hands full, I think. We are already seeing cases across the entire spectrum of different practice areas, but it's very early days. So I expect a lot more companies to pop up here.
Oh, sorry. We got to give preference to the panelists.
I just, one quick question for you. And I think it's very clever you did the venture capital use case as you think about going out to a larger group of investors, because that will certainly resonate and strike a chord. But as you're talking about kind of the next stages of the company and you look at the room and there's folks from the financial services side, other lawyers, investors, anything that can be most helpful for you as you think about the next step here?
Well, what's been interesting is I think we've seen a pretty wide range of responses to this technology and I think what it could do, what it can't do. So I would say feel free to take the gloves off in your questioning. We've heard everything from this is wonderful and this is going to help so many people to this is terrifying. How are they doing this without a lawyer involved? And I think probably somebody in this room maybe gave us that comment. So we are, part of the reason why we engage in these dialogues is because it is so early on and this feedback, this is by no means intended to be a completed work of art on our museum class, right? This is very much still the architecture process and we're engaging with legal ethics attorneys, with regulators, with other legal tech companies who have been through this before, to design the architecture up front in a way that avoids all those pitfalls from a regulatory landscape, from just a consumer tech company landscape, and also tries to please everybody. I mean, there are a lot of different stakeholders here, right? There are consumers, there are investors, there are attorneys, there are legal aid organizations, which we are working very hard on partnering with to leverage as a distribution channel to, that's the solution that was built for this problem, right? Is legal aid, but they are way too understaffed and they just don't have the resources. And so for every one person the legal aid organization can help, they have to turn away anywhere from 1 to 10 other people. That's a lot of overflow that we could pick up, I think, very easily. But you have to build out the product in a way that engenders trust and engenders the confidence that we can manage those clients in a way that would be that the legal aid organization can stand behind as a reference to us. So that's a long-winded way of saying, ask us the important questions so that we can work together to land on an answer that actually makes its way into how we're building the thing.
Hunter, you're gonna give him a heavy hitter question.
You're talking about the source of data being existing municipality or otherwise law cases around for employment law and tenant representation, et cetera, right? But the bulk of those cases, the consumer didn't have good representation or represented themselves. And so how do you make certain that you didn't train your model off of biased cases, right? So you have your library of outcomes from an underrepresented and underserviced group. Could that lean your advice towards biased outcomes rather than, like, how do you differentiate between a good outcome in that library for someone who had proper representation versus an outcome that was driven by them not being prepared for that medium, right? So you could see how you could get drift in your deviation of what success means for that underrepresented consumer. How do you control for that, knowing that I perceive like your intention based on what you described is to move that needle in the favor of better representation for consumers. But if you're training it off of data without it, how do you control to lift that to a place that is values success as you see it?
Well, that's perfect. Ask and you shall receive, I think, is what we just saw there. That's exactly the type of question that I think we want to be engaging with. And so let's definitely follow up on this. But I think, remember, we are in a position where we can draw from across jurisdictions and from across both case law and statutes, right? So it's not as if we're limited to just one body of information. And we actually, the wonderful thing about this is that the technology is very scalable. The only two elements that are preventing this technology from scaling into different jurisdictions outside of the US are the data and the regulatory framework. And so, as long as you can find a solution of both of those, getting clean data and getting it plugged in and having the right regulatory approach, you can go in any of these markets and you can actually draw inferences from across those markets in a very sophisticated way, which is interesting. So I think to answer your question directly, it's something that we do have to overcome. That's a challenge. That's a real challenge. But that is a similar to challenge that is faced by any existing attorney, right? So it is not something that I think we have to address on our own. I think it's something that we have to address as a profession. And as lawyers who are going and looking up a case in LexisNexis or Westlaw normally would have to do, and we have to find one and see whether it cuts against them or cuts for them. And is this the appropriate application of the statute? That is the similar work that we're doing as a lawyer would have to do it right now. So I wouldn't want to be so bold as to say that's a problem that exists for the entire legal profession. We're going to be the ones to solve it. I think it's something that we want to engage with the legal profession to solve jointly.
Cool. Thanks.
Hi guys, first of all, Portia, thank you so much, and panelists, thank you. Terrific. Going back to your original point, or maybe what drove this to begin with, which was the access to justice. I'm curious as to how much traction you've gotten in the trial courts that you referenced. So most of the consumers don't know lawyers, right, to your point, or don't have any access to any of the conversations that are happening in this room. So generally what they do is walk into their local courthouse. to get the answers that this technology provides. Have you had any luck with trial court states in your sales pitch? And what does that look like?
Yeah, that's interesting. So we actually haven't begun engaging with trial courts yet. I think it's something that we very much would like to. There are a couple organizations out in Arizona and Utah that are building self-service kiosks that they then would place inside of these courthouses, and they're just, I think in their best form, the idea is that they're very easily accessible. They're in the place where people are already visiting. But remember, those organizations, they're funded by grants. They're funded by, in many cases, legal services corporation grants, which have a ton of restrictions on them. And the grant money that they have access to, we're talking $10,000, $20,000, $30,000 at most. And so the extent of what they're able to do is really limited by that funding source. And I think this is exactly where the opportunity is for venture capital, because we can do far more, right? We have access to the best quality engineers in AI, machine learning, designers who can build this stuff in a way that's really accessible by users. There's been a ton of academic literature on how to design court websites best. And it is a conversation that is siloed within legal academia and doesn't draw on any of the learnings from the broader tech ecosystem, right? I mean, there are billions of dollars spent on designing apps to make them as easily accessible as possible for users. And none of that makes its way into the court system and these websites and how they design even the pamphlets. And it's because they're these very siloed systems. So I was having a conversation yesterday. I had the opportunity to speak at a class at Harvard Law School called Access to Justice in the Digital Age. And I was having a conversation with a professor there who made the point, said, hey, beyond just courthouses, right, which is already an excellent place to look at from a distribution standpoint, why don't you have conversations with Walmarts and grocery chains and all these places where people are already going and could very easily access it? Now, this is very similar to some of the challenges that we had to face at my first company I founded, which is Charlie Hernandez. So we were dealing with a consumer there that many cases had just arrived to the country, right? Have come from a country that has a lot of instability in the political and economic infrastructure, so that they don't trust the government, don't trust banks, don't want to put their money in a bank, and they don't speak the language, right? So you have a lot of those challenges in terms of how you access them, and that's what we cut our teeth on. We had to come up with a lot of creative ways to do it, from just being on the ground and working with community leaders. And I would say the challenge here is different. Some ways harder, in some ways actually a lot easier than that was. So there are a lot of things that can be done, and it's early days. So we look forward to engaging with trial courts to do what you just described.
Just to follow up on that, Charlie, so there is, just from an investment perspective, for every dollar invested in that space alone, the savings to local governments would be exponential. Our trial courts are overwhelmed. You referenced housing and probate family court. I think you're right, very close statistically, that the amount of self-represented litigants and the resources that are spent in just helping someone know where the restrooms are, right? I mean, in a courthouse, which is really foreign for most of us to navigate, there's huge opportunity in that space, I think.
And you have to deal with all those same language issues, right? That we're available in any language right now. You can upload a document in English and ask your question in Mandarin, you'll get an answer.
There's a shortage in interpreters just in the state of Massachusetts. It's almost impossible to get an interpreter. It delays access to justice for the consumer. Maybe people become impatient. Maybe their ride share was only there for 3 hours, and they, there's lots of.
But by the way, that doesn't come without challenges, right? There are regulations out there, to your point, to govern the how you are allowed to provide a translation for legal information, and they are restrictive. I know this because so when we were looking at offering banking products at Credit Verso, I did a deep dive into what the OCC, what the FDIC all said on how consumer retail banking could or could not provide access to products in other languages. And what I found was, I don't think anybody's going to be surprised in here, they refused to take a stance on it. Everybody said, well, we suggest you should consider, perhaps, maybe. And the result is, if you're a compliance officer inside a bank, you look at that and you say, well, I'm just not going to offer products in any other language besides English because I don't know what they're telling me. I don't know what the risk is. And you see a similar patchwork of ambiguous regulations here that produce an outcome where, yes, everybody would love if we had 100% absolutely perfect guidance in every single language. Is that realistic? Who knows? Can we get to 90%, 95% and far improve on the existing state of things? Maybe.
All right, we have time for about one more question.
It's a great idea, and as I've listened to other questions, I have come up with more. So I have I don't know, 4 or 5 part question, but let me kind of run down the things that went through my head. So the first question is this actually being used by the consumer type person? Because a lot of people don't understand technology or have even access to the equipment so that it may be your constituency ideally, but they're less able to navigate that on their own. Is your system interactive so that you ask somebody to download a contract? Well, what is a contract? And many of the people don't have anything other than a relationship. Maybe they get statements from their employer of how much they're being paid. They've had conversations. What a human lawyer would do would interview and gather information and so forth. So the question in terms of your system, is it sufficiently interactive to drill down and do the sorts of things a lawyer might do? The other thing is there are organizations, and I'm very familiar with the Volunteer Lawyers Project, which provide shorthand advice to people. They have hotlines and so forth. So your technology would be incredibly useful to an organization like that. They have a lawyer for the day program, so volunteer, but they're not familiar necessarily with the rules of the housing court. So having a way that they could get that information immediately and represent somebody literally on the take, but they're getting legal representation would also be very valuable. So the question underlying that is, have you been working in, drilling down and working with organizations like that? Because I think that's probably on the consumer side, the ideal market for you.
Okay, so let me see if I can keep all those questions in mind as I go through answering them. So I think the first one, in terms of how we're active with consumers and how interactive it is. So what we tried to do in that initial demo is show the distinction between if someone were to ask a question to Google or even ChatGPT, and if they were to ask a question to us. So Google, I think we all understand kind of what answer you would get if you said, my employer stopped paying my salary. You're going to get something very generic, very basic, and it's certainly not going to do what you described, which is drilling down and identifying what those important contextualizing pieces of information are. Now, ChatGPT, one thing that it is unfortunately not good at is gathering that context. And it's not the fault of the technology, right? It is unfortunately the fault of the consumer. Consumers are not good at framing their questions in a way that a lawyer can easily respond to. And that is very much the role of the lawyer, I think, in many of these instances, is to say, okay, when someone walks in my door and says, my employer stopped paying my salary, I don't just say, okay, here's what you can do. You have a lot of follow-up questions you need to ask before you can get anywhere close to the point of starting to generate a strategy behind how to address it. That is, well, I mean, for starters, what state are you in? Have you had communications with them? Do you have a contract? Have you XYZ 1, 2, 3? Or there's so many different ways it should go. And that is precisely how I think we have designed the software to engage that way. Now, is it going to do everything the lawyer can? No, but that's where we want to make sure that we can include lawyers at all those critical decision points where we say, all right, well, one of a piece of something that someone in your situation might do here is draft a demand letter. Here's a sample demand letter that you might look at, but this is also a point where we would say this is a good opportunity to talk to a lawyer and run this demand letter by them. We just received a settlement agreement. Here's what we think the settlement agreement says, and here's how it would affect you. But this is also an opportunity to talk to a lawyer and get that contextualizing information. So that's kind of on that question. I hope that answers that set of questions. On the next portion, which was how
I guess how are there consumers actually using your product now, or is it still in the formation stage?
Oh, no, there are consumers using it. Yeah, it's on a limited basis. We're testing. We have a lot of work we still want to do, but we definitely have consumers using it. And we're seeing some really interesting stuff. That use case that you saw, that was a real consumer. That was a real consumer who came to us and had a wage theft issue. Using just the technology, she was able to navigate her way through generating demand letter, receiving a settlement agreement worth a good deal of money. And, you know, at that point, she escalated to an attorney, which as the technology advisor to, but that's something she never would have gotten to without that technology. On the next side, which is the legal aid organization. So you're exactly right. That is there's a huge need there. They do wonderful work and they're way too limited by the resources that they have access to, whether it's grant money, volunteers, time. So I think part of how we are very much looking to engage with those organizations is by offering them some level of access to this tool in a way that maybe we can optimize it for how they specifically need to use it so that we can magnify both of our reach and help the consumer that way. So to that end, anyone here who works with those organizations, we definitely want to chat with them. This office have already put us in touch with Boston Chamber of Commerce, organizations. We want to do that as much as we can.
I want to thank everybody for coming. I want to thank the panelists. What an interesting time to be a lawyer. What an interesting time to be a founder. For the lawyers in the room, a lot of you have been looking at the product and sort of fielding questions and thoughts that you might have, and I've been passing them on to Charlie just so he can noodle on them or address them. So please reach out if you have thoughts or want to chat with Charlie. And thank you. And I know it technically ends at 10:30, but feel free to grab some food and mingle and chat as your time allows. So thanks, everybody.